By the time a case arrives here, the facts have been established in a trial court. This court considers the legal questions. Did the lower court apply the law properly? Is the law constitutional? The justices meet weekly in conference to choose which cases the court will accept and decide, and to discuss and vote on cases which have already been argued. Chief Justice Rehnquist and Justices O'Connor, Thomas, and Breyer talked with Dick Howard about their work.
You're actually living the fact that people who wrote this document called the Constitution somehow managed to produce words that actually guide us in solving problems that occur 200 years later.
I think one of the most amazing things about the process for granting certiorari or denying it is the fact that every petition, whether it's filed by high-priced legal counsel or whether it's written by some prisoner sitting in jail someplace in his own hand, gets the same individual consideration. And in a country the size of ours, with the number of petitions we have, I think that's remarkable.
If you decide not to take a case, isn't there an implicit affirmation of the result
There isn't.
of that case below? There's
It
not.
has no precedential value, a denial of certiorari.
I think some of the public reporting on what we say confuses what we've done in the cert process. When we don't take a case, often it is reported that the Supreme Court today upheld or the Supreme Court today ordered, when in fact we've done no such thing.
Right.
Chief Justice Taft said that 2 courts is enough for justice as between the individuals, your trial and at least 1 appeal. For this court to intervene, there ought to be something more than just a sense that one of these parties didn't get quite what they should have gotten under the law.
What was it like the first time you ever went into the conference room? I mean, it's a mystery to everybody else, and then suddenly you're appointed to the court and it's your first conference.
That first conference was the most striking moment of the entire procedure as far as I was concerned, because all of a sudden I was sitting at the table with the 9 justices actually participating in resolving some of these very difficult issues. It was just an electric moment for me.
You feel very, very daunted by the presence of 8 people who've had a lot more experience at it than you've had and a lot more knowledge of it. But you know, you're there, you have a commission just like the others, so you participate in the debate.
What's the first thing you do? You come into the room, you settle down to business, do you?
Shake hands
Shake
is the
hands.
first thing. Every time we meet, before we go on the bench or before we have a conference, each justice shakes every other justice's hand. That's good, because I think when you've touched someone's hand, you're less likely to hold a grudge, if you will, should we end up disagreeing on the merits about something.
Let's assume now an oral argument has taken place, and now in conference you're about to actually take up the final disposition of that case. What happens?
Well, I begin the discussion by briefly outlining what seemed to me the issues in the case, and everybody has their say. And at conferences I used to participate in before I became Chief Justice, there tended to be cross-questioning and people speaking twice before anyone had had a chance to speak once. And since in my 14 years as an Associate Justice, I rose to the rank of 7th in seniority, which I'm sure is some sort of a record for creeping rather than walking, I had been frustrated by that. And so I determined and pressed as hard as I could on my colleagues to have a system where everybody spoke once before anyone spoke twice. And I think we pretty much have that now.
Do you find yourself leaving the conference with sometimes with a different view of a case from how you came into it?
Absolutely. The approach that I like to take is to have an answer for each case before I come in, and to have that in an outlined form, so I know how I'm going to decide the case. From time to time, that view changes in conference, but my views don't change that often in conference.
One of the difficulties every justice faces is that over time, it's as though we have walked through a patch of fresh concrete. We've left footprints behind us as we go with some of the opinions we've written, and then it becomes less open to change.
I did want to ask a question about the mystique of the court. I take it the court prides itself on keeping some distance between itself and the larger public.
Well, I take issue with that. I think the court is remarkably open.
People think sometimes it's secret because they have in mind a legislature. A legislature doesn't produce all the reasons in public. A judiciary, a court, has no secrets because it's all out there in the opinion. And the inside story of a court is there is no inside story. It's people simply thinking.
One thing people should understand about the Supreme Court is that the judges can't come in the morning and say, well, here's a problem we ought to deal with, the way a senator can, or a president can, or a governor, or a mayor. They have to wait for people to bring their problems to the courts. So you mustn't think that that's just a bunch of activist judges going in there to do something. It's because that issue has boiled up in the country, and it's been taken to the court. The court doesn't have to decide everything, but when issues knock at the door, sooner or later the court is going to have to say, yes, we'll decide it.
The Supreme Court hears cases in public. Lawyers on opposing sides of each case are allowed 30 minutes to make their arguments before the court. Oral argument is an hour of high drama, where 9 of the nation's highest officials do their work in public.
Set the stage for oral argument. Basically, you come into the courtroom, what do?
I view the oral argument as simply an opportunity to ask the hard questions that the briefs raise in your mind.
You often think of the oral argument. You have a point in mind that you think may not have been brought out in the briefs well, but you want to be sure your colleagues don't overlook.
That's so important.
Well, ask a question to bring it out, and you're not necessarily trying to sell everybody on the position, but you want everybody to have at least the point in mind.
When the people come in this room, the public, to see our arguments, they often see a dialogue between a justice who's asking a question and the attorney answering it. And they think of the argument as a series of these dialogues. It isn't that. As John points out, what is happening is the court is having a conversation with itself through the intermediary of the attorney.
Mm-hmm. Let me put myself in the shoes of a lawyer. I'm here arguing a case for the first time. What do you expect me to do? What are you looking for from me?
Well, first you want to crank the lectern up or down. So
first
that
I'll
it's
adjust
right
it to the appropriate height.
Right. I think really you should have asked Ruth to answer the question, because you know she's argued more cases before the court than the rest of us combined.
Oh, absolutely.
Ruth is really the experienced advocate.
And won most of them, too.
What was it like to stand here and argue a case?
The first time I argued a case here, I didn't have lunch. I was first up in the afternoon because I didn't know whether I could keep it down. I was initially terribly nervous. And after about 2 minutes into the argument, I looked up at these guys and I said, I have a captive audience. They have no place to go for the next half hour. They must listen to me. And it was a feeling of power. And then there was the challenge of rolling with the waves, sometimes the punches, trying to elicit what's in the decision makers' minds rather than sticking to a prepared spiel. I think it's a good idea to have a great opening sentence and a great close if you have time.